welcome to the deep dive. Today, we're taking a deep breath and diving into a recent Supreme Court decision that reveals the really strict rules of when a legal fight is truly, absolutely over. It sounds like, a dry procedural ruling about filing deadlines, but it's actually a high-stakes lesson in litigation strategy.
It absolutely is.
We are dissecting the case of BLOM Bank SAL v. Honickman. And the real-world context here is just intensely serious.
Oh, absolutely.
This lawsuit was brought by victims and families of victims of Hamas terrorist attacks from, 2 decades ago. They sued BLOM Bank under the Anti-Terrorism Act, or JOSTA.
Right, alleging the bank aided and abetted these attacks by providing financial services to Hamas-affiliated customers.
But here's the twist, and this is what we have to focus on. The Supreme Court wasn't deciding whether the bank financed terrorism.
No, not at all.
This was purely about procedure. Specifically, whether the plaintiffs, after losing their case, deserved a second chance to fix their paperwork.
Yeah.
It forces us to look at this fundamental tension in American law.
That tension is the whole game here. Our mission today is to sort of give you a shortcut to understanding this dense legal fight.
Okay.
We're going to unpack 2 very specific federal rules of civil procedure, Rule 60b-6 and Rule 15a, and show you exactly why the Supreme Court decided that, the stability of final judgments has to win out.
Okay, let's unpack this by starting at the very beginning of the lawsuit, because the choices the plaintiffs made early on really set this whole thing in motion.
Exactly. When the plaintiffs brought their suit under JOSTA, they were alleging that BLOM Bank was, essentially part of the machine.
By giving financial support.
Right. And the legal standard for this kind of claim requires showing the bank had a certain level of what's called general awareness.
And that's where the first problem came up, right?
That's the initial roadblock. The district court looked at the complaint and basically said, you failed to adequately allege that the bank had this necessary general awareness.
So what does that mean in plain English?
Think of it this way. To be liable, the bank needs to know more than just, this is a customer. They needed to be generally aware that their services were helping customers involved in terrorist activities.
And the first complaint just didn't connect those dots.
It fell short. And what happened next is crucial. The district court dismissed the entire case.
And not just dismissed it, but dismissed it with prejudice.
Which, for anyone unfamiliar, is the legal equivalent of a final nail in the coffin.
You can't just refile it the next day, it's over.
It's done. But what's really central to the Supreme Court's later reasoning is what happened before that dismissal.
Ah, right. The sources show that the district court actually gave the plaintiffs multiple opportunities to fix their complaint.
Multiple chances. They could have sought leave to amend, add more details, strengthen their case.
And they said no.
They did, repeatedly. They basically affirmed they would not seek to amend. It was a strategic, deliberate choice.
To stand on the paperwork they already had.
Exactly. The district court even called it a documented series of deliberate choices. They gambled that their complaint was good enough as is.
A gamble they lost. So they appealed that dismissal to the Second Circuit Court of Appeals.
And the Second Circuit affirmed the dismissal, meaning the plaintiffs still lost the case.
But there's always a but.
Here's where the crack in the wall appeared. While the Second Circuit said, yes, you lose, they also offered a clarification on the legal standard.
Okay.
They said, wait a minute, the district court actually used too strict a standard for what that general awareness element required.
So even though they lost, they got a kind of moral victory.
A procedural one. The appellate court essentially confirmed that the rules of the game had changed between the lower court and the appeal. And that gave the plaintiffs an opening.
An opening that leads us right to the main event.
Yeah.
This clash between 2 competing federal rules.
The conflict between flexibility and finality.
Okay, so let's start with the first one, Rule 15a. I think of this as the flexibility rule.
That's a great way to put it. It governs amendments before a final judgment. It's got this famous language that courts should freely give leave when justice so requires.
It's all about making sure cases are decided on the actual facts, not because someone
made a typo.
Right.
It's about getting to the merits.
But once that final judgment hammer drops, Rule 15 is off the table.
It's functionally irrelevant. And you move to a much tougher rule, Rule 60b-6.
Which you've called the emergency exit rule.
Exactly. It's a catch-all provision you can only use after a case is closed and sealed. It lets a party ask the court to relieve them from a final judgment for any other reason that justifies relief.
We should probably stress just how narrow this is. The rules before this, B1 through B5,
Yeah.
cover very specific things, right? Like fraud, Or clerical mistake.
Very specific, rare events. So if your reason doesn't fit in one of those neat boxes, you have to try and squeeze into this catch-all beat.
And the Supreme Court has always demanded an incredibly high standard for it.
Oh, yeah. They've consistently held that you have to demonstrate extraordinary circumstances. And this isn't just about procedure. It's about the philosophy of the entire legal system.
Because finality is the bedrock.
It has to be. Businesses, families, everyone needs certainty. If you win a case, you need to know it's really won. If we allow endless do-overs, the whole system just grinds to a halt.
So, back to our plaintiffs. They have this clarification from the appeals court, and they go back to the district court with a clever but pretty aggressive move.
Very aggressive. They use Rule 60b-6, the emergency exit rule, to try and vacate the final judgment.
The idea being if you vacate the judgment, the case is technically open again.
And then once it's open, you can use the much friendlier Rule 15a to file your new improved complaint.
It's like asking for a do-over on the whole game.
That's what it is. And the district court said no, but then the Second Circuit, on review, actually sided with the plaintiffs.
They tried to kind of split the difference.
They did. They held that when a party is only seeking Rule 60b relief to file an amended complaint, courts should balance the need for finality with Rule 15's liberal amendment policy. They tried to create a hybrid rule.
A lower bar, basically.
A much lower bar.
And this is where the Supreme Court steps in and delivers the final word.
The final, definitive word. They looked at this balancing act and gave a resounding answer. No balancing.
Just a flat no.
That's the entire lesson of this case. The court said the strict Rule 60b-6 standard of extraordinary circumstances does not get watered down just because you promise you'll file a better complaint.
They laid out a strict order of operation.
A very strict one. First, you must satisfy the extraordinary circumstances test of Rule 60b. You have to get the case reopened.
Only then can you even think about Rule 15.
Only then. Trying to balance them, the court said dilutes Rule 60b-6 stringent standard. Finality is the gateway, and you can't negotiate your way through it.
So this raises the big practical question for all of us. If getting a favorable legal clarification from an appeals court isn't an extraordinary circumstance, then what on earth is?
It's a great question. And the court's opinion actually uses these two fascinating historical cases to show just how high that bar is.
Okay.
The first case is Claprot. This shows what is extraordinary. This guy was fighting to keep his citizenship, but at the same time, he was thrown in jail on criminal charges.
So he couldn't defend himself.
Exactly. He was in jail, sick, no lawyer. He was physically and legally incapable of responding to the court. The system made it impossible for him to fight.
That sounds like a true emergency, a situation where he was totally faultless.
The court agreed. That was extraordinary. Now contrast that with the second case, Ackerman.
Okay.
He also had a judgment against him, but he made a choice. He decided not to appeal because it was expensive, and someone told him he'd probably lose anyway. Years later, he tried to reopen the case.
And the Supreme Court said no.
A hard no. And they gave us the phrase that defines this whole area of law. They said the difference between the two cases was no choice and choice.
No choice versus choice.
Claprot had no choice. Ackerman made a free, calculated, deliberate choice. And the rule that comes from that is that extraordinary circumstances must suggest the person is faultless in the delay.
So a bad strategic call isn't an excuse.
Rule 60b-6 is not a safety net for a bad call.
Which brings us right back to the BLOM Bank plaintiffs.
The Supreme Court said, first, a change in the law or a clarification like the one they got rarely constitutes extraordinary circumstances. Otherwise, old cases would be reopening constantly.
And second,
and this was the killer for their argument, their own series of deliberate choices not to cure the deficiencies cut directly against them.
they weren't faultless.
Far from it. Their situation was a direct result of their own strategy. So the Supreme Court reversed the Second Circuit and upheld the district court's original denial.
Case closed. For good this time.
Now, there is one last fascinating piece of nuance here from Justice Jackson's concurring opinion.
So she agreed with the result, but not necessarily all of the reasoning.
Exactly. She agreed. No balancing, the 60B standard applies. But she had a problem with the district court faulting the plaintiffs for their deliberate choice to appeal instead of amend.
What was her issue with that?
Well, she pointed out that appealing is a statutory right. Why should someone be penalized or considered at fault just for exercising their legal right to ask a higher court if the lower court got it right?
That's a really good point. If you discourage appeals, you might be discouraging the very process that clarifies the law for everyone.
That's her argument. We need appeals to settle important legal questions, like what general awareness means under JASTA. Penalizing people for appealing could leave those questions unanswered.
So what was her conclusion?
She agreed that in this case, the legal clarification wasn't extraordinary enough to reopen the case, but she sent a warning to lower courts. Don't automatically deny these motions just because someone chose to appeal first. Fault should be for, true negligence, not for the strategic pursuit of a legal right.
This has been a masterful deep dive, so let's try to put a bow on this. For our listeners, what's the single biggest takeaway from BLOM Bank SAL v. Honickman?
The main takeaway is that the Supreme Court has drawn a very bright line protecting judicial finality. Flexibility is for pretrial. The moment a final judgment is entered, that flexibility vanishes.
And the bar for reopening is?
Astronomically high. It requires those extraordinary circumstances that show you were essentially powerless and faultless. The strategic choices you make early on can and will have permanent consequences.
A powerful warning. And this case involves such grave claims, victims seeking redress under JASTA. Now that this procedural door is slammed shut for this specific complaint, it leaves us with a final thought to mull over. How will future plaintiffs in similar situations need to adjust their strategy to avoid these exact pitfalls, ensuring they amend early and leave absolutely nothing to chance?
That strategic adjustment is probably already underway in courtrooms across the country.
A truly high-stakes procedural deep dive. Thank you for guiding us through this.
My pleasure.
Until next time, keep digging deeper.